So I'm going to be reading the Supreme Court ruling for the TikTok Incorporated et al. Petitioners against Attorney General Garland, so the United States government, that came out today. It was earlier this morning, January 17th, 2025. As of January, it says per curiam. As of January 19th, the Protecting Americans from Foreign Adversary Controlled Applications Act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless U.S. operation of the platform is severed from Chinese control. Petitioners are two TikTok operating entities and the group of U.S. TikTok users. We consider whether the act, as applied to petitioners, violates the First Amendment. In doing so, we are conscious that the cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter advised 80 years ago in considering the application of established legal rules to the, quote, totally new problems, end quote, raised by the airplane and radio, we should take care not to embarrass the future. And then it says Northwest Airlines Incorporated versus Minnesota, 322 U.S. 292 300, 1944. That caution is heightened in these cases given the expedited time allowed for our consideration. Our analysis must be understood to be narrowly focused in light of these circumstances. It says TikTok is a social media platform that allows users to create, publish, view, share, and interact with short videos overlaid with audio and text. Since its launch in 2017, the platform has accumulated over 170 million users in the United States and more than 1 billion worldwide. Those users are prolific content creators and viewers. In 2023, U.S. TikTok users uploaded more than 5.5 billion videos, which were in turn viewed more than 13 trillion times around the world. Opening the TikTok application brings a user to the, quote, for you, end quote, page, a personalized content feed tailored to the user's interests. TikTok generates the feed using a proprietary algorithm that recommends videos to a user based on the user's interactions with the platform. Each interaction a user has on TikTok, watching a video, following an account, leaving a comment, enables the recommendation system to further tailor a personalized content feed. A TikTok user's content feed is also shaped by content moderation and filtering decisions. TikTok uses automated and human processes to remove content that violates the platform's community guidelines. And then it says see Appendix 493, 497 through 497. TikTok also promotes or demonstrates certain content to advance its business objectives and other goals. See ID at 499, 501. TikTok also promotes, I think I said that. Yes. TikTok is operated in the United States by TikTok Incorporated, an American company incorporated and headquartered in California. TikTok Incorporated's ultimate parent company is ByteDance Ltd., a privately held company that has operations in China. ByteDance Ltd. owns TikTok's proprietary algorithm, which is developed and maintained in China. The company is also responsible for developing portions of the source code that runs the TikTok platform. ByteDance Ltd. is subject to Chinese laws that require to, quote, assist or cooperate with the Chinese government's, quote, intelligence work, end quote, and to ensure that the Chinese government has, quote, the power to access and control private data, end quote, the company holds. And then it says HR Rep number 118 through 417, page 4, 2024. In recent years, U.S. government officials have taken repeated actions to address national security concerns regarding the relationship between China and TikTok. In August 2020, President Trump issued an executive order finding that, quote, the spread in the United States of mobile applications developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States, end quote. Executive Order number 13942, 3 CFR 412 in 2021. President Trump determined that TikTok raised particular concerns, noting that the platform, quote, automatically captures vast swaths of information from its users, end quote, and is susceptible to being used to further the interests of the Chinese government. The president invoked his authority under the International Emergency Economic Powers Act and the National Emergencies Act to prohibit certain, quote, transactions, end quote, involving ByteDance Ltd. Or its subsidiaries as identified by the Secretary of Commerce. The Secretary published a list of prohibited transactions in September of 2020. See 85 Fed Regulation 60061 in 2020. But federal courts enjoined the prohibitions before they took effect, finding that they exceeded the executive branch's authority under the IEEPA. See generally TikTok Incorporated versus Trump, number 504F, supplemental 3D92 DC 2020, or Marland versus Trump, 498F, supplemental 3D 624, Ed. PA 2020. Just days after issuing his initial executive order, President Trump ordered ByteDance to divest all interests and rights in any property, quote, used to enable or support ByteDance's operation of the TikTok application in the United States, end quote, along with, quote, any data obtained or derived from, end quote, U.S. TikTok users. ByteDance Ltd. And TikTok Incorporated filed suit in the D.C. Circuit challenging the constitutionality of the order. In February of 2021, the D.C. Circuit placed the case in abeyance to permit the Biden administration to review the matter and to enable the parties to negotiate a non-divestiture remedy that would address the government's national security concerns. See Order in TikTok Incorporated versus Committee on Foreign Investment, number 20-1444, CADC, February 19th, 2021. Throughout 2021 and 2022, ByteDance Ltd. negotiated with executive branch officials to develop a national security agreement that would resolve these concerns. Executive branch officials ultimately determined, however, that ByteDance Ltd.'s proposed agreement did not adequately, quote, mitigate the risks posed to the U.S. national security interests, end quote. It says the reference is to APP 686. Negotiations stalled and the parties never finalized an agreement. Against this backdrop, Congress enacted the Protecting Americans from Foreign Adversary Controlled Applications Act, which has the reference of Pub L 118-50. Division H 138 Stat 955. The act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary controlled application, end quote, in the United States. Entities that violate this prohibition are subject to civil enforcement actions and hefty monetary penalties. The Act provides two means by which an application may be designated a, quote, foreign adversary controlled application, end quote. First, the Act expressly designates any application that is, quote, operated directly or indirectly, end quote, by, quote, ByteDance Ltd., end quote, or, quote, TikTok, end quote, or any subsidiary or successor thereof. Second, the Act establishes a general designation framework for any application that is both one operated by a, quote, covered company, end quote, that is, quote, controlled by a foreign adversary, end quote, and, quote, determined by the president to present a significant threat to the national security of the United States, end quote. Following a public notice and reporting process, in broad terms, the act defines, quote, covered company, end quote, to include a company that operates an application that enables users to generate, share, and view content and has more than 1 million active users, monthly active users. The act excludes from that definition a company that operates an application, quote, whose primary purpose is to allow users to post product reviews, quote, business reviews, quote, comma, or travel information and reviews, end quote. The act prohibitions take effect 270 days after an application is designed or is designated. The act prohibitions take effect 270 days after an application is designated a foreign adversary-controlled application. Because the act itself designates applications operated by, quote, ByteDance Ltd, end quote, and TikTok, quote, TikTok prohibitions as to those applications take effect 270 days after the act's enactment, January 19th, 2025. The act exempts a foreign adversary-controlled application from the prohibitions if the application undergoes a, quote, qualified divestiture. I don't know why I can't say that, but end quote. A qualified divestiture is one that the president determines will result in the application, quote, no longer being controlled by a foreign adversary, end quote. The president must further determine that the divestiture, quote, precludes the establishment or maintenance of any operational relationship between the United States operations of the application and any formally affiliated entities that are controlled by a foreign adversary, including any corporation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. The act permits the president to grant that was an end quote. The act permits the president to grant a one-time extension of no more than 90 days with respect to the prohibitions, 270-day effective date, if the president makes certain certifications to Congress regarding progress toward a qualified divestiture. ByteDance Ltd and TikTok Incorporated, along with 2 sets of TikTok users and creator petitioners, filed a petition for review in the D.C. Circuit, challenging the constitutionality of the act. As relevant here, the petitioners argued that the act's prohibitions, TikTok-specific foreign adversary-controlled application designation, and the divestiture requirement violate the First Amendment. The D.C. Circuit consolidated and denied the petitions, holding that the act does not violate petitioners' First Amendment rights. That has a reference of 122F, 4th, 930, 940, 948 through 965, CADC, and 2024 as the year. After first concluding that the act was subject to heightened scrutiny under the First Amendment, the court assumed without deciding that strict rather than intermediate scrutiny applied. The court held that the act satisfied that standard, finding that the government's national security justifications countering China's data collection and covert content manipulation efforts were compelling, and that the act was narrowly tailored to further those interests. Chief Judge, I don't know how to say this, Srinivasan, concurred in part and in the judgment. In his view, the act was subject to immediate scrutiny and was constitutional under that standard. We, another word that I'm not going to be able to say very well, we granted certiorari to decide whether the act as applied to petitioners violates the First Amendment. At that threshold, we consider whether the challenged provisions are subject to First Amendment scrutiny. Laws that directly regulate expressive conduct can but do not necessarily trigger such a review. They have a reference to CRAV, lowercase v, St. Paul, so versus RAV versus St. Paul 505 US 377, 382-386 in 1992. We have also applied First Amendment scrutiny in cases involving governmental regulation of conduct that has an expressive element, and to, quote, some statutes which, although directed at activity with no expressive component, impose a disproportionate burden upon those engaged in protected First Amendment activities, end quote. Their reference is Arcara versus Cloud Books Incorporated, 478 U.S. 697, 703-704 in 1986. It is not clear that the act itself directly regulates protected expressive activity or conduct with an expressive component. Indeed, the act does not regulate the creator petitioners at all, and it directly regulates ByteDance Ltd. And TikTok Incorporated only through the divestiture requirement. C2C1. Petitioners, for their part, have not identified any case in which this court has treated a regulation of corporate control as a direct regulation of expressive activity or semi-expressive conduct. See TR of oral argument 37 through 40. We hesitate to break that new ground in this unique case. In any event, petitioners' arguments more closely approximate a claim that the Act's prohibitions, TikTok's specific designation, and divestiture requirements, quote, impose a disproportionate burden upon, end quote, their First Amendment activities. Arcara 48 U.S. at 704. Petitioners assert, and the government does not contest, that because it is commercially infeasible for TikTok to be divested within the Act's 270-day timeframe, the Act effectively bans TikTok in the United States. Petitioners argue that such a ban will burden various First Amendment activities, including content moderation, content generation, access to a distinct medium for expression, association with another speaker or preferred editor, and receipt of information and ideas. We have recognized a number of these asserted First Amendment interests. See Moody versus NetChoice LCC 603 U.S. 707, 371, 2024. In parentheses, an entity exercising editorial discretion in the selection and presentation of content is engaged in speech activity, end quote. Also quoting Arkansas Ed Television Com versus Forbes 523 U.S. 666, 674, 1998. Alteration omitted. Also, they looked at, it looks like City of Ladue versus Gileo. I'm not going to read those numbers. Our prior decisions have voiced particular concern with laws that foreclose an entire medium of expression. They also looked at Rumsfeld versus Forum for Academic and Institutional Rights Incorporated. Not going to read the numbers. It was 2006. We have recognized a First Amendment right to associate for the purpose of speaking, which we have termed a, quote, right of expressive association. Also case Martin versus City of Struthers, 1943. In quotes, the right of freedom of speech and press embraces the right to distribute literature and necessarily protects the right to receive it. Citation omitted. And an effective ban on a social media platform with 170 million U.S. users certainly burdens those users' expressive activity in a non-trivial way. At the same time, a law targeting a foreign adversary's control over a communications platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. Those differences, the Act's focus on a foreign government, the congressionally determined adversary relationship between that foreign government and the United States, and the causal steps between the regulations and the alleged burden on protected speech may impact whether First Amendment scrutiny applies. This court has not articulated a clear framework for determining whether a regulation of non-expressive activity that disproportionately burdens those engaged with the expressive activity triggers heightened review. We do not do so here. We assume, without deciding, that the challenged provisions fall within this category and are subject to First Amendment scrutiny. In quotes. At the heart of the First Amendment lies the principle that each person should decide for himself or herself the ideas and beliefs deserving of expression, consideration, and adherence. That's from Turner Broadcasting System Incorporated versus the FCC in 1994. Government action that suppresses speech because of its message, quote, contravenes this essential right, end quote. And then the next quote, content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests, end quote. And that is from Reed versus Town of Gilbert in 2015. Content-neutral laws, in contrast, quote, are subject to an intermediate level of scrutiny because in most cases, they pose a less substantial risk of exercising certain ideas or viewpoints from the public dialogue, end quote. That's from Turner 1. The citation is omitted. Under that standard, we will sustain a content-neutral law, quote, if it advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests, end quote. Turner Broadcasting System Incorporated versus the FCC in 1997, Turner 2. We have identified two forms of content-based speech regulation. First, a law is content-based if on its face, First, a law is content-based on its face if it, quote, applies to particular speech because of the topic discussed or the idea or message expressed, end quote. Read, the case is Read 576 U.S. at 163 to 164, explaining that some facial distinctions define regulated speech by subject matter, others by the speech's function or purpose. Second, a facially content-neutral law is nonetheless treated as a content-based regulation of speech if it, quote, cannot be justified without reference to the content of the regulated speech, end quote, or was, quote, adopted by the government because of disagreement with the message the speech conveys, end quote. And it's quoting Ward versus Rock Against Racism in 1989. As applied to petitioners, the challenge provisions are facially content neutral and are justified by a content neutral rationale. The challenge provisions are facially content neutral. They impose TikTok-specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target particular speech based upon its content. Contrast, for example, Kerry versus Brown in 1980, statute prohibiting all residential picketing except peaceful labor picketing. Or regulate speech based on its function or purpose, contrast Holder versus Humanitarian Law Project in 2010, law prohibiting providing material support to terrorists is what I'll call it. No, nor do they impose a, quote, restriction, penalty, or burden, end quote, by reason of content on TikTok, a conclusion confirmed by the fact that the petitioners, quote, cannot avoid or mitigate, quote, the effects of the act by altering their speech. Turner 1, referencing the case above, Turner 1. As to petitioners, the act thus does not facially regulate, quote, particular speech because of the topic discussed or the idea or message expressed, end quote. Then they're referencing the case Reed, page 163 in that one as well. Petitioners argue that the act is content-based at its face because it excludes from the definition of covered company and company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. See brief for petitioners number 24-656 on pages 26 through 27, brief for TikTok. Brief for petitioners number 24-657, page 26, brief for creator petitioners. We need not decide whether that exclusion is content-based. The question before the court is whether the act violates the First Amendment as applied to petitioners. To answer that question, we look to the provisions of the act that give rise to the effective TikTok ban that petitioners argue burdens their First Amendment rights. The exclusion for certain review platforms, however, applies only to the general framework for designating applications controlled by covered companies, not to the TikTok-specific designation. As such, the exclusion is not within the scope of practitioners' as applied challenge. The government also supports the challenge provisions with a content-neutral justification preventing China from collecting vast amounts of sensitive data from 170 million U.S. TikTok users. That rationale is decidedly agnostic. That rationale is decidedly content agnostic. It neither references the content of speech on TikTok nor reflects disagreement with the message such speech conveys. And then it references CF Ward 491 US at 792 and 793, holding noise control and sound quality justifications behind city sound amplification guideline where we're content neutral. Because the data collection justification reflects a, quote, purpose unrelated to the content of expression, end quote, it is content neutral. The Act's TikTok-specific distinctions, moreover, do not trigger strict scrutiny. See brief for TikTok 26 through 27, brief for creator petitions 24 through 26. It is true that, quote, speech restrictions based on the identity of the speaker are all too often simply a means to control content, end quote. Citizens United versus Federal Election Communication, I think it's communication. It's abbreviated 558 US 310 340 in 2010. For that reason, quote, regulations that discriminate among media or among different speakers within a single medium often present serious First Amendment concerns, end quote, referencing Turner 1 case. But while the, quote, laws favoring some speakers over others demand strict scrutiny when the legislature's speaker preference reflects a content preference, end quote, such scrutiny is, quote, unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated, end quote. And that's quoted from Minneapolis Star and Tribune Company versus Minnesota Com something of revenue in 1983. For the reasons we have explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing the sensitive data of 170 million U.S. TikTok users is not, quote, a subtle means of exercising a content preference, end quote. Turner 1 case that they're referencing. The prohibitions, TikTok-specific designation, and divestiture requirement regulate TikTok based on a content-neutral data collection interest. And TikTok has special characteristics, a foreign adversary's ability to leverage its control over the platform to collect vast amounts of personal data from 170 million U.S. users that justify this differential treatment. Quote, speaker distinctions of this nature are not presumed invalid under the First Amendment, end quote. While we find the differential treatment was justified here, however, we emphasize that the inherent narrowness of our holding. Data collection and analysis is a common practice in this digital age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. A law targeting any other speaker would by necessity entail a distinct inquiry and separate considerations. On this understanding, we cannot accept petitioners' call for strict scrutiny. No more than an intermediate scrutiny is in order. As applied to petitioners, the Act satisfies intermediate scrutiny. The challenge provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest. The Act prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance Ltd. To capture the personal data of U.S. TikTok users. This objective qualifies as an important government interest under immediate scrutiny. Petitioners do not dispute that the government has an important and well-grounded interest in preventing China from controlling the personal data of tens of millions of U.S. TikTok users, nor could they. The platform collects extensive personal information and about its users. See HR Rep at 3. Public reporting has suggested that TikTok's, quote, data collection practices extended to age, phone number, precise location, internet address, device use, phone contacts, social networking connections, and content of private messages sent through the application and videos watched, end quote. 1 App 241, Draft National Security Agreement, noting that TikTok collects user data, user content, behavioral data, including keystroke patterns and rhythms, and device and network data, including device contacts and calendars. If, for example, a user allows TikTok to access the user's phone contact list to connect with others on the platform, TikTok can access, quote, any data stored in the user's contact list, end quote, including names, contact information, contact photos, job titles, and notes. Access to such detailed information about U.S. users, the government worries may enable, quote, China to track the locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage, end quote. And Chinese law enables China to require companies to surrender data to the government, quote, making companies headquartered there an espionage tool of China, end quote, of China. HR Rep at 4. Rather than meaningfully dispute the scope of the data TikTok collects or the ends to which it may be used, petitioners contest probability, asserting that it is unlikely that China would, quote, compel TikTok to turn over user data for intelligence gathering purposes, since China has more effective and efficient means of obtaining relevant information. Brief for TikTok 50, internal quotation marks omitted. In reviewing the constitutionality of the act, however, we, quote, must accord substantial deference to the predictive judgments of Congress, end quote, referencing Turner 1 case again, opinion of Justice Kennedy. Quote, sound policymaking often requires legislators to forecast future events and to anticipate the likely impact of these events based on deductions and inferences for which complete empirical support may be unavailable. Here, the government's TikTok-related data collection concerns do not exist in isolation. The record reflects that China, quote, has engaged in extensive and years-long efforts to accumulate structured data sets, in particular on U.S. persons, to support its intelligence and counterintelligence operations, end quote. Even if China has not yet leveraged its relationship with ByteDance Ltd. To access U.S. TikTok users' data, petitioners offer no basis for concluding that the government's determination that China might do so is not at least a, quote, reasonable inference based on substantial evidence, end quote. They're referencing Turner 2. We are mindful that this law arises in context in which, quote, national security and foreign policy concerns arise in connection with efforts to confront evolving threats in an area where information can be difficult to obtain and the impact of certain conduct difficult to assess. I'm going to read that sentence again. We are mindful that this law arises in context in which, quote, national security and foreign policy concerns arise in connection with efforts to confront evolving threats in an area where information can be difficult to obtain and the impact of certain conduct difficult to assess, end quote. That's referencing Humanitarian Law Project. We thus afford the government's, quote, informed judgment, end quote, substantial respect here. Petitioners further argue that the act is under-inclusive as the government's data protection concern, raising doubts as to whether the government is actually pursuing that interest. In particular, petitioners argue that the act's focus on applications with user-generated and user-shared content, along with its execution for certain review platforms, exempt from regulation applications that are, quote, as capable as TikTok of controlling Americans' data, end quote. And it says, see the brief for TikTok and brief for creator petitions, pages 43 on the first one and 48 through 49. It might not be pages, it could be lines. But the, quote, First Amendment imposes no freestanding under-inclusiveness limitation, end quote. And the government, quote, need not address all aspects of the problem in one fell swoop, end quote. Williams Yulee versus Florida Bar in 2015, internal quotation marks are omitted. Furthermore, as we have already concluded, the government had good reason to single out TikTok for special treatment. Contrast Brown versus Entertainment Merchants, Association in 2011, singling out purveyors of video games for disfavored treatment without a persuasive reason, quote, raised serious doubts about whether the government was in fact pursuing the interests invoked rather than disfavoring a particular speaker or viewpoint, end quote. On this record, Congress was justified in specifically addressing its TikTok-related national security concerns. I'm on page 16, if you're wondering where I'm at in the Supreme Court.gov ruling that came out today. Page 16 at the top. Per curiam 2. As applied to petitioners, the act is sufficiently tailored to address the government's interest in preventing a foreign adversary from collecting vast swaths of sensitive data about the 170 million U.S. persons who use TikTok to survive intermediate scrutiny. Quote, a regulation need not be the least speech restrictive means of advancing the government's interests, end quote, referencing Turner 1 again at 662. Rather, the standard is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation, end quote, and does not, quote, burden substantially more speech than is necessary, end quote, to further that interest, referencing Ward at 799, quoting United States versus Albertini in 1985, alteration omitted. The challenge provisions meet this standard. The provisions clearly serve the government's data collection interests, quote, in a direct and effective way, end quote. Again, quoting Ward at 800, the prohibitions account for the fact that absent a qualified divestiture, TikTok's very operation in the United States implicates the government's data collection concerns, while the requirements that make a divestiture, quote, qualified ensure that those concerns are addressed before TikTok resumes U.S. operations. Neither the prohibitions nor the divestiture requirement, moreover, is, quote, substantially broader than necessary to achieve this national security objective. Rather than ban TikTok outright, the act imposes a conditional ban. The prohibitions prevent China from gathering data from U.S. TikTok users unless and until a qualified divestiture serves China's control. Petitioners parade a series of alternatives, disclosure requirements, data sharing restrictions, the proposed national security agreement, the general designation provision that they assert would address the government's data collection interests in the equal measure of conditional TikTok ban. Those alternatives do not alter our tailoring analysis. Page 17 at the top. Petitioners' proposed alternatives ignore the, quote, latitude, end quote, we afford the government to design regulatory solutions to address content-neutral interests, referencing Turner 2 case at 213. Quote, so as long as the means chosen are not substantially broader than necessary to achieve the government's interest, ... The regulation will not be invalid simply because a court concludes that the government's interest could be adequately served by some less speech restrictive alternative, end quote. That's Ward 491 U.S. at 800. In parentheses, regulation valid despite availability of less restrictive alternate regulatory methods, end parentheses. They're also referencing Clark versus Community for Creative Nonviolence, in 1984, members of City Council of Los Angeles versus Taxpayers for Vincent in 1984. For these reasons, we have explained the challenged provisions are, quote, not substantially broader than necessary, end quote, to address the government's data collection concerns, again, referencing Ward at 800. Nor did the government ignore less restrictive approaches already proven effective. The contrast is McCullen versus Coakley. In 2014, it says, in parentheses, state law burdens substantially more speech than necessary where state had not considered less restrictive measures successfully adopted by other jurisdictions, end parentheses. The validity of the challenge provisions does not turn on whether we agree with the government's conclusion that its chosen regulatory path is best or, quote, most appropriate, end quote, referencing Albertini at 689. Quote, we cannot displace the government's judgment respecting content-neutral regulations with our own so long as the policy is grounded on reasonable factual findings supported by evidence that is substantial for a legislative determination, end quote. Referencing Turner 2 at 224. Those requirements are met here. We're in section D now of this at almost the top of page 18. At the end of 17, moving into 18. In addition to the data collection concerns addressed above, the government asserts an interest in preventing a foreign adversary from having control over the recommendation algorithm that runs widely used U.S. communications platform and from being able to wield that control to alter the content on the platform in an undetectable manner. See Appendix 6, I think it's Appendix, see Second Appendix 628. In petitioners' view, that rationale is a content-based justification that quote, taints the government data collection interest and triggers strict scrutiny. Brief for TikTok 41. Petitioners have not pointed to any case in which this court has assessed the appropriate level of First Amendment scrutiny for an act of Congress justified on both content-neutral and content-based grounds. They assert, however, that the challenge provisions are subject to and fail strict scrutiny because Congress would not have passed the provisions absent the foreign adversary control rationale. See brief for TikTok 41 to 42, brief for creator petitioners 47 through 50. We need not determine the proper standard for mixed justification cases or decide whether the government's foreign adversary control justification is content neutral. Even assuming that rationale turns on content petitioners' argument, fails to start that one over. Even assuming that rationale turns on content, petitioner's argument fails under the counterfactual analysis they propose. The record before us adequately supports the conclusion that Congress would have passed the challenge provisions based on the data collection justification alone. To start, the House report focuses overwhelmingly on the government's data collection concerns, noting the, quote, breadth end quote, of TikTok's data collection. Quote, the difficulty in assessing precisely which categories of data, end quote, the platform collects, the, quote, tight interlinkages, quote, between TikTok and the Chinese government, and the Chinese government's ability to quote, coerce, end quote, companies in China to, quote, provide data, end quote. That's from HR Rep at 3, 5 through 12, and in parentheses it says, recounting a 5-year record of government actions raising and attempting to address those very concerns, end parentheses. Indeed, it does not appear that any legislator disputed the national security risks associated with TikTok's data collection practices, and nothing in the legislative record suggests that data collection was anything but an overriding congressional concern. We are especially wary of parsing Congress's motives on this record with regard to an act passed with striking bipartisan support. And then it has references to March 13th, 2024 for H1170, and then also Congressional Record S2992 from April 23rd, 2024. Petitioners assert that the text of the act itself undermines this conclusion. In particular, they argue that the government's data collection rationale cannot justify the requirement that a qualified divestiture preclude, quote, any operational relationship that allows for cooperation with respect to the operation of a content recommendation algorithm or agreement with respect to data sharing, end quote. See brief for creators 4849. We disagree. The government has explained that ByteDance Ltd. uses the data it collects to train the TikTok recommendation algorithm, which is developed and maintained in China. According to the government, ByteDance Ltd. has previously declined to agree to stop collecting U.S. user data or sending that data to China to train the algorithm. See Second Appendix 705 to 706. The government has further noted the difficulties associated with monitoring data sharing between ByteDance Ltd. And TikTok Incorporated. See at 692 through 697. Under these circumstances, we find the government's data collection justification sufficient to sustain the challenged provisions. There is no doubt that for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with foreign adversary. For the foregoing reasons, we conclude that the challenge provisions do not violate petitioners' First Amendment rights. The judgment of the United States Court of Appeals for the District of Columbia Circuit is affirmed, so it is ordered. That is the document in its whole, other than the commentary, I think, that comes next from Justice like Sotomayor, and then there's ones from Justice Gorsuch. And then they go on to give all the comments from each of the justices that I don't know if they all have to write something or if it's just like, I think just a couple of them. I might read those actually because there's not many here. Just like a couple, I think. So this says Supreme Court of the United States. It says January 17th, 2025, Justice Gorsuch concurring in judgment. And this is what they have to say. We have had a fortnight to resolve, finally, and on the merits, a major First Amendment dispute affecting more than 170 million Americans. Briefing finished on January 3rd. Argument took place on January 10th, and our opinion issue on January 17th, 2025. Given those conditions, I can sketch out only a few and admittedly tentative observations. First, the court rightly refrains from endorsing the government's asserted interest in preventing, quote, the covert manipulation of content, end quote, as a justification for the law before us. Brief for Respondent 37. One man's, quote, covert content manipulation, quote, is another's, quote, editorial discretion, end quote. Journalists, publishers, and speakers of all kinds routinely make less than transparent judgments about what stories to tell and how to tell them. Without question, the First Amendment has much to say about the right to make those choices. It makes no difference that Americans, like TikTok Incorporated and many of its users, may wish to make decisions about what they say in concert with a foreign adversary. Quote, those who won our independence, end quote, knew the vital importance of the, quote, freedom to think as you will and speak as you think, end quote, as well as the dangers that come from repressing the free flow of ideas. Whitney versus California, 1927. Then it says Justice Brandeis concurring. They knew, too, that except in the most extreme situations, quote, the fitting remedy for evil counsels is good ones, end quote. Too often in recent years, the government has sought to censor disfavored speech online as if the internet were somehow exempt from the full sweep of the First Amendment. See, for example, Murphy versus Missouri in 2024 and Justice Alito dissenting. So not agreeing. But even as times and technologies change, quote, the principle of the right to free speech is always the same, end quote. Abrams versus United States, 1919, Justice Holmes dissenting. Second, I am pleased that the court declines to consider the classified evidence the government has submitted to us, but shielded from petitioners and their counsel. Efforts to inject secret evidence into judicial proceedings present obvious constitutional concerns. Usually, quote, the evidence used to prove the government's case must be disclosed to the individual so he has an opportunity to show that it is untrue, end quote. Green versus McElroy, 1959. Maybe there is a way to handle classified evidence that would afford a similar opportunity in cases like these. Maybe, too, Congress or even the Standing Committee on Rules of Practice and Procedure would profit from considering the questions. CF United States versus Zabida, 2022, Justice Gorsuch dissenting. But as the court recognizes, we have no business considering the government's secret evidence here. Third, I harbor serious reservations about whether the law before us is, quote, content neutral, end quote, and thus escapes, quote, strict scrutiny. And then it has a bunch of references there as well. More than that, while I do not doubt that the various, quote, tiers of scrutiny, end quote, discussed in our case law, quote, rational basis, strict scrutiny, something's in between, end quote, can help focus our analysis. I worry that litigation over them can sometimes take on a life of its own and do more to obscure than to clarify the ultimate constitutional questions. And then referencing Riddle versus Hickenlooper, Justice Gorsuch concurring. Fourth, whatever the appropriate tier of scrutiny, I am persuaded that the law before us seeks to serve a compelling interest, preventing a foreign country designated by Congress and the president as an adversary of our nation from harvesting vast troves of personal information about tens of millions of Americans. The record before us establishes that TikTok mines data both from TikTok users and about millions of others who do not consent to share their information. According to the Federal Bureau of Investigation, TikTok can access, quote, any data, end quote, stored in a consenting user's, quote, contact list, end quote, including names, photos, and other personal information about unconsenting third parties. And because the record shows that the People's Republic of China, PRC, can require TikTok's parent company, quote, to cooperate with its efforts to obtain personal data, end quote, there is little to stop all that information from ending up in the hands of a designated foreign adversary. The PRC, People's Republic of China, may then use that information to, quote, build dossiers for blackmail, end quote, quote, conduct corporate espionage, end quote, or advance intelligence operations. First Appendix 215, see Second Appendix 659. To be sure, assessing exactly what a foreign adversary may do in the future implicates, quote, delicate, end quote, and, quote, complex, end quote, judgments about foreign affairs and requires, quote, large elements of prophecy, end quote. Chicago, and then they reference Chicago and Southern Airlines Incorporated versus Waterman SS Corp. 333 U.S. 103 111, 1948, and Justice Jackson for the court. But the record the government has amassed in these cases after years of study supplies compelling reason for concern. Finally, the law before us also appears appropriately tailored to the problem it seeks to address. Without a doubt, the remedy Congress and the president chose here is dramatic. The law may require TikTok's parent company to divest or effectively shutter its U.S. operations. But before seeking to impose that remedy, the coordinate branches spent years in negotiations with TikTok exploring alternatives and ultimately found them wanting. And from what I can glean from the record, that judgment was well-founded. Consider some of the alternatives. Start with our usual and preferred remedy under the First Amendment, more speech. However helpful that might be, the record shows that warning users of risks associated with giving their data to a foreign adversary-controlled application would do nothing to protect non-users' data. Forbidding TikTok's domestic operations from sending sensitive data abroad might seem another option, but even if Congress were to impose serious criminal penalties on domestic TikTok employers who violate the data sharing ban, the record suggests that would do little to deter the People's Republic of China from exploiting TikTok to steal Americans' data. And then see First Appendix 214, noting threats from, quote, malicious code, backdoor vulnerabilities, superstitious surveillance, and other problematic activities tied to source code development, end quote, in the People's Republic of China. The second Appendix 702 quote, agents of the People's Republic of China would not fear monetary or criminal penalties in the United States, end quote. The second record also indicates that the size and complexity, quote, size, end quote, and complexity, that's in quotations, of TikTok's, quote, underlying software, end quote, may make it impossible for law enforcement to detect violations. Even setting all these challenges aside, any new compliance regime could raise separate constitutional concerns, for instance, by requiring the government to surveil Americans' data to ensure that it isn't illicitly flowing overseas, suggesting that effective enforcement of a data export ban might involve direct U.S. government monitoring of the, quote, flow of U.S. user data, end quote. Whether this law will succeed in achieving its end, I do not know. A determined foreign adversary may just seek to replace one law surveillance application with another. As time passes and threats evolve, less dramatic and more effective solutions may emerge. Even what might happen next to TikTok remains unclear. And then it says CTR of oral argument 146 through 147. But the question we face today is not the law's wisdom, only its constitutionality. Given just a handful of days after oral argument to issue an opinion, I cannot profess the kind of certainty I would like to have about the arguments and record before us. All I can say is that at this time and under these constraints, the problem appears real and the response to it not unconstitutional. As persuaded as I am of the wisdom of Justice Brandeis on Whitney, the case Whitney, and Justice Holmes in Abrams, the case Abrams, their cases are not ours. See Supra at 2. Speaking with and in favor of a foreign adversary is one thing. Allowing a foreign adversary to spy on Americans is another. And that's the end of that justice's thing. I think it might have flooded into like two different ones there. That was just Gorsuch. Let me see if I missed the other one. That's Justice Gorsuch. Okay, so I'm going to scroll up because I missed Justice Sotomayor, which is much shorter. So Justice Sotomayor's comments on this from today, January 17, 2025. Concurring in part and concurring in the judgment. I join all but part 2.A of the court's per curiam opinion. I see no reason to assume without deciding that the act implicates the First Amendment because our precedent leaves no doubt that it does. TikTok engages in expressive activity by compiling and curating material on its platform, referencing Moody versus Net Choice in 2024. Laws that, quote, impose a disproportionate burden, end quote, upon those engaged in expressive activity are subject to heightened scrutiny under the First Amendment. Arcara versus Cloud Books Incorporated, 1986. See Minneapolis Star and Tribune Company versus Minnesota Com of Revenue, 1983. The challenged act plainly imposes such a burden. It bars any entity from distributing TikTok speech in the United States unless TikTok undergoes a qualified divestiture. The act, moreover, effectively prohibits TikTok from collaborating with certain entities regarding its, quote, content recommendation algorithm, end quote, even following a qualified divestiture. And the act implicates a content creator's, quote, right to associate, quote, with their preferred publisher, quote, for the purpose of speaking, end quote, referencing Rumsfeld versus Forum for Academic and Institutional Rights, 2006. That, too, calls for First Amendment scrutiny. As to the remainder of the per curiam opinion, I agree that the act survives petitioner's First Amendment challenge. That's all the comments that are there from the justices. For those of you that stuck around for it, good job. Good job caring about what is actually being said. I'm going to probably download this if TikTok will allow it. So I'm going to end my live so I don't get any restrictions on it. And then I will post it to YouTube so that if there's somebody that thank you. So if there's somebody that wants to go and listen to this later because they have a hard time reading a document, that was my purpose of reading it on live, was to make it more accessible for other people. I'm not perfect at how to pronounce things. I am not like well-versed in legalese whatsoever. I'm just an American citizen that ain't happy about her speech being suppressed. And I will be grateful for every moment that I get on this app. And, all I have to say is like, don't give your personal phone number out to people because you never know what someone's going to do with it. If you want your personal data secured, don't share it because you also can't control what Joe Smith does with your phone number or Jane Doe does with your phone number. If you don't want people to know your date of birth, don't share your birthday because this is just ridiculous to think that any of this stuff would be private once you share it. If you want something secret, keep it a secret. It's really not that hard. If you don't like that people already have that information, then go ahead and change your name. Move to a new location and change your phone number and start fresh. But what you decided to share along the way is your responsibility as a human. What people do beyond when you share whatever it is that you're sharing, you can't control. And that's a spiritual thing. Okay? Like you got to be able to let go of that idea. All of these countries, all of these adversaries already have plenty of information on plenty of us. This isn't something like new. If you don't want your personal things out there, don't put them on electronics. Don't send them to people in text messages. Only go face to face with people. Live off the grid. If that's how if like you're so concerned about other people getting your data, don't engage with it. But just like when you get in a car, there's a risk. When you fly in a plane, there's a risk. You can't control what the pilot's going to do. You can't control how that manufacturer created your car or whether they put some software in there that's going to make your car start driving off into a ditch. You don't know. You can walk with your two legs, but still there's going to be some people out there that could run right into you. There's risk in this world. And you can live in a protective bubble or you can just go, I don't care. If people are being blackmailed, then don't care about it. Don't do things that you're ashamed of or get rid of the idea of shame. So you have some spicy videos out there that could be leaked. Well, make sure they're legal. Make sure they're legal. So you got some weird quirks that you like. Okay. Don't be ashamed of it then. Embrace your weirdness. Then you have nothing to blackmail. You don't want your wife to know that you're having an affair? Then don't have one. You don't want it leaked out there that you're doing inappropriate things with inappropriate people that's illegal? Then don't do it. The only reason that blackmail could be a problem is if you are carrying shame about something. I prefer to live authentically. Whatever's on my phone, am I going to pass it out like candy? No, but if some foreign adversary decides to use it as blackmail, okay, then I'll address that. And I'll go, yeah, they stole my crap. I'm into whatever. I said whatever, like own it. I personally am not secretive about a lot of things in my life that I like or dislike or say. I show up authentically. I also know that there's a line of what people want to know about me and what they don't want to know about me. But if someone leaked something about me, I'd own it. I'd wear it. I'd fly my freak flag. And then I'd also say that was a little bit like inappropriate to expose the world to that. Like, why'd you do that? That's like, I don't think people wanted to know that much about me, but maybe they were that curious. There's risk in this world. And, do I think that it's important that we be able to block an app from downloading our contacts? Sure. But when you click that button of invite your friends or find your friends, or yes, I give you access to my contacts data, or yes, I give you access to my contacts data, well, you push the button, you know? I could see Apple and Google app stores having restrictions that say your coding can't say that you are that can't access our iOS system or our operating system's contact fields, or you can't be an app. And yeah, that might restrict people from being able to find their friends easily. But okay, so take that away, you know? Thank you. I just think it's such an overreach from our government system. I think it is such a precedent being set on our First Amendment right, our rights to gather together, our rights to communicate with one another in whatever ways we want to, our rights to choose what news outlet, what platform we want to be on. Thank you so much. I don't know who just did that with subscribers, but I didn't catch that. But I appreciate all of your guys' support. I hope that you will take time to follow me on YouTube. It's ascending.phoenix, just like on here. I still haven't lost hope on this app. It may be shut down for a little bit. People may scatter for a while. It may be gone for forever. It may be gone for a short period. A lot of people may move on to something different. And I get that, I understand that we can rebuild anywhere. We're phoenixes. We rise from the ashes. That's the whole point of my entire, that's my whole point of my entire account, is the idea that, yeah, we burn down and then we rise again. And that's great, cool. At least we can rise up again. But, if I've got to, personally for my family, if I have to go out and supplement in some other way while I rebuild, that's what I'll do. No problem. That's fine. But you won't see me working for the man for the rest of my life. This is not the end for me. This is not the end for everybody else. We will rise in another place or in this place. I don't plan to stop being quiet about this, absolute infringement on my rights. Thank you, Bryn. I appreciate that so much. Thank you. Yeah, we will continue to rise. So I'm going to hop off of here and then probably restart a live because I want to be able to upload this one to YouTube without having to do much editing. Probably no editing. I'm probably going to put the whole thing up there. So I'm going to just hop off now so that, someone doesn't come in and report something so I can't download it.